Does the outcome of this trial affect you personally? Cohen, yes. Joining us now is Jeremy Saland, a criminal defense attorney and a former Manhattan assistant district attorney. Thank you for being with us. This is an interesting kind of line of questioning. So, is the outcome of this trial affecting you personally? Yes. What is that intended to get?
They're working with what they have. They only have so much. And one of the big points is the credibility of Michael Cohen, the agenda of Michael Cohen, and the financial gain of Michael Cohen. The agenda being, I abhor this man. I detest this man. I want to see the worst things happen to him. He made me go to jail. He's made me be the fall guy. I can make money off this, which I have, and I'm admitting to making money off of this. And I've lied to my wife. I've lied to Congress. I've lied to the court under oath. So whatever they can, they got to keep on going after with him. If you diminish him and you make him look like just a bad guy, what does it do? It steals away that this is really a falsifying business records case, and you make it the Michael Cohen case. And if you can't believe Michael Cohen, you can't believe this whole house of cards.
Well, it's what comes after that, what seemed to be a moment in court with that question, does the outcome of this trial affect you personally? And Cohen says yes. Then I'm still trying to figure out why Blanche decides to just move on right after that, because this is where he goes in his very next question. Blanche, do you or your lawyers say anything to Judge Pauley that you felt pressured by the government to make a guilty plea? Cohen did not. Blanche, by the way, your wife had nothing to do with the leasing agreements. Cohen, some of the millions were solely in her name. Some of the medallions, corporations were in her name. Blanche, when you received monthly payments, the checks were made to you or your wife. Cohen, the corporations, names. There were 16. So now we're just completely in a different area. I'm wondering what the strategy is here, Anna, in that he didn't let that moment sit with the jury. He moves on.
Well, part of this is balancing letting the moment sit with the moment happened, right? And he now gets to use that. And I think one thing that's really important for us to remember is the jurors are going to be instructed on credibility, and credibility does not just have to do with truthfulness, right? It doesn't just have to do with whether someone has lied or not. It's whether they're believable. And here he's getting into another area, which is not just the lying, but the bias and motive. And so when they get that instruction, the jurors, when they get that instruction, they're going to be told all about all the different things that they can consider with respect to credibility. And these are big areas, right? So that bias, that motive, the reasons why he does things just for himself, those are the things that the jurors are going to be looking at and considering when they consider the credibility, the believability of Cohen. So this is very smart by the defense.
And Chuck, this is kind of one of the pillars that you were talking about earlier, the different pillars that the defense has to erect. When they ask him, does the outcome of this trial affect you personally? And he say yes. And then they go into the medallion taxis and the millions of dollars that he lost as a consequence of being involved in this. That is a different pillar.
It's a different pillar, but there may be a salutary reason for switching at that point. Mr. Blanche got the answer he wanted. It was a bad answer. I mean, a witness on the stand, under oath, admitted that he had a personal interest in the outcome of the case. The witness's interest in a case should be to tell the truth and that justice be done. Cohen said, no, I really care what happens here. I want this guy in jail. I want this guy convicted. So Blanche took the answer, as we were taught to do as prosecutors, put it in his pocket and moved on. I'm not sure it's a terrible strategy, frankly, because, Anna, if you want to dwell on a good answer that you just got, it could get worse, right? I mean, maybe Cohen recognizes what he did and said and then tries to clean it up if you ask him another question. You got the answer you want? Move on.
Absolutely.
Jeremy, what is that answer?
Well, on summation, I think that's a great point, because on summation now you can say, and you know why he said that? Here are the reasons why. Because it's not in evidence, and you're allowed to tell your story on summation. What's in evidence is the answer, but why, how we got to that answer is not in evidence, and that's a great tool for the defense on summation to hit on and hit on and hit on, just like they will on all these other things about the agenda and the money and the, as you said, credibility in all its forms.
Is there a point in cross-examination where the jury's going to feel like this has been tied up in a bow in terms of what the defense is trying to accomplish in their cross-examination?
There is, but there's no magic wand that I, as a defense attorney, could say, oh, you got it, we're done. Thank you very much. I wish it worked that way, and so does the prosecution. It doesn't. So you have to be able to gauge that, and it's not always easy. As a defense attorney and as a prosecutor, but more so as a defense attorney, sometimes you go and you hit and you got to stop. It doesn't help, and eventually there's diminishing returns, and you got to walk it back. But it's not so easy in the moment when you are kind of like, taking that water fountain and it's turning into an open fire hydrant of information. So it's not always easy.
And if I may, as a prosecutor, I always felt that there was no such thing as too much evidence, right? You don't know when you've hit the point. You have to prove your case beyond a reasonable doubt to a unanimous jury. How many more witnesses are going to do that for me? Or did I do it 8 witnesses ago? And so I want to keep going as a prosecutor, though mindful of what Jeremy is saying. You may have already crossed that threshold. Sometimes, at least in federal court where I practice, the judge would stop you. But I wasn't going to stop me.
But speaking of which, when you talk about the sort of arc of witnesses, Michael Cohen's supposed to be the prosecution's last witness. That's what they have told Judge Merchan. And so, Anna, what do you make of that choice?
Well, I don't think it should come as a surprise to anyone that they're ending with him. In fact, when I heard that they were thinking they might have one other witness after him, I was a little surprised, because you want to start strong, you want to end strong. And so in their mind, they're ending with their strong witness, right? They're ending with this witness that ties everything together.
But a flawed witness, as we've pointed out, as the defense has pointed out.
Definitely a flawed witness. But, what they're going to do, which others have sort of said, is they're going to say to the jury, he comes to you as a person, just like anyone else. And we, the prosecution, don't get to pick our witnesses. And I can tell you this both from experience of my own in practice and having watched tons and tons of trials. Juries convict all the time based on the testimony of a witness who has multiple convictions, has lied, and has admitted, I've lied. But please believe me, jury. And the jurors say, OK, we will, and we'll convict.
And interesting.